Alright guys, welcome back to the Butterfly Monkey channel. Hopefully you guys are caught up with the other three videos on this topic. And of course this topic is on passports and the right to travel and a study of administrative controls on the citizen. And if you are following, then of course you know that this is a congressional document from 1966. First published in 1956, but this is a great read so far. Let me get back to where I left off at. This video will be almost completely on court cases. And it's on purpose because the other stuff was, general talk by the author of Authority, or that guy who wrote this. But now they're going to start breaking down to court cases. So without further ado, let's continue. Bauer versus Atchison, 1952. One Bauer, a naturalized American citizen, worked as a journalist and sojourned in Europe from 1944 to 1951 on an American passport. On June 4, 1951, the Secretary of State, without notice or hearing, revoked Bauer's passport. The Secretary failed to give any reason for the revocation or refusal to renew the passport other than the statement that, in the Secretary's opinion, her activities are contrary to the best interest of the United States. Bauer sued, contending, among other things, that such action was unconstitutional and violated the Due Process Clause of the Fifth Amendment. The Secretary pleaded his right to exercise discretion under Title 22, Section 211. With respect to this point, the court stated, it is the contention of the defendant that a passport is a purely political document addressed to foreign powers. So the defendant is, of course, the Secretary of State. And they give you the court case. I can't pronounce this, but this is the court case. I have to look this up because I'm looking for court cases that deal with due process. Oh, look right here. 1835, that's how far back it goes. 34 U.S. 692. Let's make sure it's the same case, though. Yep, 34 U.S. 692. Yep, damn, that's an old case. And that since a passport is in the realm of foreign affairs, its issuance or denial is a political matter, entirely in the discretion of the Secretary of State and not subject to judicial review. It is true that the conduct of foreign affairs is a political matter within the discretion of the executive and legislative branches of the government, and that the courts recognize the plenary power of the President and of Congress singly or in combination to perform acts peculiarly within the realm of political affairs without judicial interference, which is true. But he's assuming that this is too. Or they are, right? There is, however, the recognized limitation on the power of the political departments. I'm going to highlight this right here because I know this is going to be good stuff. Power of the political departments of the government, and their acts must be within the Constitution and not in conflict with any provision thereof. With respect to the violation of the Fifth Amendment, the court stated, the plaintiff's contention that Section 211A is in violation of her rights under the Due Process Clause of the Fifth Amendment of the Constitution raises a more serious problem. The Fifth Amendment provides no person shall be deprived of life, liberty, or property without due process of law. The Supreme Court has recognized that personal liberty includes the right of locomotion, the right to remove one from one place to another according to inclination. And that's, of course, the Fears case, which I'm going to do a video on, like I said. stating, "The liberty of which the deprivation without due process of law is forbidden," means not only the right of a citizen to be free from the mere physical restraint of his person, as by incarceration, but the term is deemed to embrace the right of the citizen to be free in the enjoyment of all his faculties, to be free to use them in all lawful ways, to live and work where he will, to earn his livelihood by any lawful calling, to pursue any livelihood or avocation. I think I highlighted this above. I think there's a repeat that they're stating right here. And they give you the other court cases, right? Quoting Alliger. So Fears quoted Alliger versus Louisiana, which I'm doing cases. I'm going to do videos on those too. While the Supreme Court was there considering freedom to move from state to state within the United States, it is difficult to see where, in principle, freedom to travel outside the United States is any less an attribute of personal liberty. In Walker v. Chief Quarantine Officer, D.C., 69 Federal Supplement. That's what they stated there. While the Supreme Court was there considering freedom to move from state to state within the United States, it is difficult to see where, in principle, freedom to travel outside the United States is any less an attribute of personal liberty. So international travel should be considered the same. Or at least considered under the same context. Especially is this true today, when modern transportation has made all the world easily accessible, and when the executive and legislative departments of our government have encouraged a welding together of nations and free intercourse of our citizens with those of other friendly countries. Personal liberty to go abroad is particularly important to an individual whose livelihood is dependent upon the right to travel, as is claimed by the plaintiff in this case, and he's a journalist. Aside from the provisions of sections 224 and 225, it is unrealistic to contend that denial of an American passport does not restrict the plaintiff's right to travel abroad. Now, aside from the provisions of 224 and 225, all right, so let's go look that up. And I'm confident it's going to be USC Title 22. What was it again? 225? 224? Yeah, 224. Oh my God, just give me 224. And that's even if it's here, right? Preservation of friendly foreign relations generally. Oh no, it's not here. It is not here. Either it's moved somewhere else in here in these documents, right? Or it's in their, what's it called? There's another book for this, right? There's another book so like when you see things that are like repealed or flat out just missing, right? There's another book for it. Man, I forgot the name of that book. It'll dawn on me in a minute. Aside from the provisions of sections 224 and 225, it is unrealistic to contend that denial of an American passport does not restrict the plaintiff's right to travel abroad. What? It is unrealistic to contend that denial of the American passport does not restrict the plaintiff's right to travel. Legal rights may be violated by unlawful public action, although such action makes no direct demands on the individual. Passports are required in many countries, and as long ago as 1929, the State Department advised American citizens leaving the United States for a country where passports are not required to carry a passport, except to travel to Canada, Mexico, and for the use to facilitate re-entry into the United States. Such denial of an American passport has a very direct bearing on the applicant's personal liberty to travel outside the United States. The Executive Department's discretion, although in a political matter, must be exercised with regard to the constitutional rights of citizens, who are the ultimate source of all government authority. Let's look up this. Oh, they stated it already. The liberty guaranteed by the Constitution is not absolute. Civil liberties, as guaranteed by the Constitution, imply the existence of an organized society maintaining public order, without which liberty itself would be lost in the excesses of unrestrained abuses. Thus, freedom to travel abroad, like other rights, is subject to reasonable regulation and control in the interest of the public welfare. However, the Constitution requires due process and equal protection of the laws in the exercise of that control. Due process of law has never been a term of fixed and invariable content. Due process does not require a judicial hearing, but merely a procedure in which the elements of fair play are accorded. Essential elements of due process are notice and an opportunity to be heard before the reaching of a judgment. L.B. Wilson Incorporated and versus the FCC, but the particular procedure to be adopted may vary as appropriate to the disposition of issues affecting interests widely varying in kind. They give a couple court cases right there. The court recognizes that in the matter of passports, the executive department of the government, acting through the Secretary of State, must necessarily be accorded wide discretion in determining when and where the protection of the United States may be extended to an American citizen traveling abroad, and that it should also have discretion to deny such protection to persons whose activities abroad might be in conflict with its foreign policy. This court does not suggest that the Secretary of State is without reasonable authority to establish reasonable classifications of persons whose passports shall be revoked or not renewed. Now, I know we all hate that word persons in some way, right? But who do you think they're talking about here? Can't be nothing else but some people. The question raised in this case is whether the inherent power of the executive department or Section 211A confers upon the Secretary of State absolute discretion in the matter of passports, without regard to the principles of due process and equal protection of the law, and whether or not this discretion be exercised arbitrarily. This court is not willing to subscribe to the view that the executive power includes any absolute discretion which may encroach on the individual's constitutional rights, or that the Congress has power to confer such absolute discretion, meaning that an act of Congress that gives an agency, right, the president or something. We hold that, like other curtailments of personal liberty for the public good, the regulation of passports must be administered, not arbitrarily and capriciously, but fairly, applying the law equally to all citizens without discrimination, and with due process adapted to the exigencies of the situation. We hold further that such administration is possible under the existing statute and regulations. Since the act in question is susceptible, and the reason why he's saying that, because it's existing, it's only because the Secretary of State is under the presumption or assumption that he has absolute discretion, right? So he's stating that the statutes don't allow that already. Like it's a given that you should be understanding the Constitution and the limits of your power. That's what he's really telling him. Since the act in question is susceptible of an interpretation which would permit due process, it follows that it is not in violation of the Fifth Amendment. The President's regulation authorizing withdrawal of passports is clearly within the intent of the Congress and is susceptible of and must be construed as exacting notice and opportunity to be heard prior to any judgment affecting revocation or refusal to renew a passport. Next case, I'm guessing, is Communist Party of the United States versus Subversive Activities Control Board, 1954. Supreme Court, 1956 was the decision for them. This case concerned the Subversive Activities Control Act of 1950, which required the Communist Action Organizations to register as such after a hearing before the board established by the act. The Communist Party of the United States was required to register. The proceedings were reviewed by the United States Courts of Appeal, District of Columbia, which upheld the findings of the board, whereupon certiorari was granted by the United States Supreme Court, which sent the case back for a retrial review because of false testimony by 3 witnesses. In the United States Court of Appeals, the court stated, with respect to Section 6 of the Act of Title 50, Section 785, which denies passports to members of communist organizations. The provision respecting passports is in Section 6 of the statute. A passport is addressed to foreign governments and requests for the holder permission to come and go, as well as lawful aid and protection. And they're quoting the Borchert Diplomatic Protection of Citizens Abroad. They quoted that earlier up top. An American passport, says Hackworth, Digest of International Law, indicates that it is the right of the bearer to receive the protection and good offices of American diplomatic and consular officers abroad, and request on the part of the government of the United States that the officials of foreign governments permit the bearer to travel or sojourn in their territories, and in case of need to give him all lawful aid and protection. Only rudimentary reasoning is necessary to a conclusion that the government may validly decline to confer its diplomatic protection upon and to request foreign governments to give aid and protection to a member of an organization operating primarily to achieve the objectives of the world movement, such as the communist movement is defined to be in the statute. Surely a government owes no duty of protection to those who, dominated by a foreign organization, seek its overthrow. Congress can narrow the scope of the passport privilege so long as the limitation is reasonable. I'll highlight this whole thing. Under current rules, a person must have a passport in order to leave the United States to go outside this hemisphere. It is urged that this is a restriction upon liberty and is without due process because unrelated to the congressional purpose. But we need not and do not enter upon consideration of that question, because whatever else a passport may validity do, it serves the purpose enumerated by Hackworth, and that feature is enough to support denial. We think this provision is directly related to the congressional purpose in this statute and otherwise valid. You notice that they use an author of authority, right? They're using principles of law to give an answer. And to be honest, that's what opinion means in law. It's not general as in, for general people, right? But in law, it It takes on principles, it takes on research, it takes on a lot of stuff, that criteria that they have to follow. Dulles versus Nathan, 1955. On December 24th, 1952, Nathan applied for a passport. When the application had been pending nearly 20 months, on August 17, 1954, he filed in the United States District Court for a declaratory judgment and an injunction directing the Secretary of State to issue the passport. On March 15, 1955, the district judge, oh my God, where'd it go? The district judge directed the Secretary of State to afford Nathan an appropriate hearing on his application. After the Secretary had not complied with the order, the judge directed him to issue the passport. The Secretary appealed to the United States Court of Appeals, District of Columbia, and a hearing was held therein on June 2nd, at which the reason for refusal was requested. Right, the reason. And it's crazy. Like, you know, they didn't even want to give him a hearing. Like, you know, that's the due process aspect. You got to be heard. Like you got to tell me why. Why are you, you know, lollygagging with my passport, with this I want to say property interest, man, but that's not truly technically correct. It's the property of the United States, and when you hold it, you have an interest. How that's labeled, I forgot. In reply, among other things, the Secretary stated, the Department of State, on the basis of the present file, including the classified investigative record of Dr. Otto Nathan, and after full and careful consideration has concluded that it would be contrary to the best interests of the United States to provide him with a passport. Whereupon the Court of Appeals entered an order prescribing the procedure to be followed by the Secretary in hearing Nathan's application as follows. Whereas it appears that the appellee applied for a passport some 2.5 years ago and was never accorded an evidentiary hearing or confronted with the evidence, if any, which led to the denial of the passport. It is ordered by the court that the said order of the district court entered June 1st, 1905 be, and it hereby is stayed until further order of this court, provided, however, 1, that the Department of State accord a quasi-judicial hearing on the appellee's application for a passport, with opportunity provided to the government and to the appellee to offer evidence, such hearing to be commenced on or before Tuesday, June 7th. So they got 6 days. And to be concluded within 3 days unless this court upon application extends the time. That the hearing, number 2, that the hearing officer or officers render a report and recommendation based on the record of such hearing within 5 days after the conclusion of the hearing. Number 3, that the appellee be immediately furnished with a copy of such report and recommendation, and be allowed 3 days within which to file objections thereto with the Department of State. Number 4, that within 10 days after the rendition of such report and recommendation, action to be taken by the Department of State, either granting or denying a passport, and a statement of such action be immediately furnished to appellee and to this court. Number 5, that if a passport is denied, the State Department immediately either A, inform this court and the appellee with particularity of the reasons for such denial, or B, show cause to this court with particularity for any failure to supply such reasons. And this right here is due process. But the court is almost damn near forcing that agency to do it. After final action of the Department of State, this court will consider what further action on its part, if any, is necessary. On the 6th of June, by memorandum, the Secretary stated that the Board of Passport Appeals had approved the application and that he had issued the passport, whereupon the case was dismissed and moot. So they get called on, right? They're doing something that's contrary to law, right? And they just flat out just approve it. They gave them 6 days and they said, screw it, let's just do it, right? And it happened in the most recent case, Jordan versus Rubio. They were denying her on the basis that she did not give enough information to establish her nationality. The court, no doubt, found that she gave copious amounts of information. But during the time when she was trying to fight this by herself without an attorney, they were screwing her over. The minute she got an attorney, their attitude changed, right? So early on in the proceedings, the Secretary of State, they changed their tune and said, okay, we'll give you a passport, just reapply. You know, not to mention that she applied like 3 times or something in the past, 6 years or something. But they're telling her to fill out the application again, send us another picture, and blah, blah, blah. Right? So, like, that judge slapped that down right there. But nonetheless, they're trying to do something because there's no doubt they see where they went wrong, especially if the judge is telling them there's copious amounts of information that establishes her nationality. And that was the legal basis of her winning. But because they tried further tactics to burden her, the religious aspect came out. And the judge had to, make an opinion on that. And he slapped, I don't know how else to put it, he slapped the Secretary of State, the agency. And that's a beatdown. That judge, some people don't like court cases. To me, I find court cases all the time where I'm finding truth tellers. That's as simple as that. Whether it's on purpose or not, right, is they're truth telling. Next case, Schachman v. Dulles. As reported, this is 1955. As reported, this was a proceeding to enjoin Secretary of State and others from denying for the reason assigned. So now they gave a reason. For the reason assigned by the Secretary, a passport application, and for judgment declaring that the denial had been upon a ground which was legally insufficient. The United States District Court for the District of Columbia, Matthew E. McGuire, dismissed, did they say judge? I'm guessing judge. Dismissed the complaint upon motion and the appellate appealed. The Court of Appeals, Fay, Circuit Judge, held that the right to travel to go from place to place as means of transportation permit is a natural right subject to the rights of others and to reasonable regulation under law, and a restraint imposed by the government of the United States upon this liberty must conform with the Due Process Clause. Reversed and remanded for further proceedings not inconsistent with opinion. The only thing they didn't do is they're not telling you what the reason is yet. But the appellate court, they found something in that reason to send it back. They reversed and remanded it. The Court of Appeals, in its opinion, stated, in the statute referred to, Congress has placed the issuance of passports in the hands of the Secretary under rules prescribed by the President. These provide the Secretary of State is authorized in his discretion to refuse to issue a passport. However, in Perkins, I'm guessing Elgin or something, in Perkins, the Supreme Court, while stating that the court's action would not interfere with the Secretary's discretion, precluded denial of a passport for the asserted reason that the applicant had lost her American citizenship when she had not done so. All right, so that's, or at least that's in Perkins, right? That the court's action would not interfere with the Secretary's discretion, precluded denial of the passport for the asserted reason that she lost her citizenship. Though that case factually is not like this one, it nevertheless shows that the subject of passport is not entirely beyond judicial assistance. And this is so notwithstanding the relation of the subject to the executive powers over the conduct of foreign affairs, for it too, like every other governmental power, must be exercised in subordination to the applicable provisions of the Constitution. I think I'm going to read this case right here. I'll go back through this though to look for these cases. Is there a provision of the Constitution applicable to the present situation? In answering this, we bear in mind that the instance of a passport is not a purely political matter. If it were, it would be a non-justiciable one, meaning he can't hear it. You know what I'm saying? The court would not be able to hear it because it is completely within that realm to do so or not. But because it's dealing with a specific natural right, right? You have opportunity at law to have your case heard. In other words, a passport is no longer a document purporting only to be a request that the bearer of it may pass freely, so safely and freely. It is no longer to be considered rather in the character of a political document by which the bearer is recognized in foreign countries as an American citizen. And if they're using this case right here, right, isn't that the court case that I just looked up? Maybe it wasn't. Was it this one? No, it wasn't that one. That I thought it was like 1830 something. Wasn't that the case right there? This one I can't pronounce. Tetique. Tetique. This description parallels early rulings of secretaries of state, opinions of attorney generals, texts, and other court decisions, which have recognized a great breadth of executive authority and discretion. And they give you a whole lot of references, more court cases. The general subject is discussed in 41 Georgetown Law Journal 63. See, like this, we could still find. This is, this should be not too difficult to find. I'm a big fan of Law Journal, so as long as I have it on the search thing, I can find it later. But there's another one here too. 3 Stanford Law Review, 312, 61 Yale, another court case. Yeah, I'm going to look up those law reviews. If you don't find them online, and if you could go to a law library that, a big one, right? For sure, you'll probably find it in the computers. But big law libraries will have these books. Whether they're up to date, I don't know. Everybody's switching to digital. But nonetheless, you'll be able to find them. We do not suggest that a passport is no longer a political document, or that its issuance is not allied to and at times a part of the conduct of foreign affairs, but only that it is not merely this character. This is why they don't have full discretion on that. For it is now, in addition, a document which is essential to the lawful departure of an American citizen for Europe. Regulations now in effect and authorized by Congress so provide. Early in our history, except, e.g., during the war between the sections. Right? I'm reading that right. War between the sections. I'm guessing states. This was not the case. It was then a desirable incident to travel, not a necessity, and was granted more or less at the pleasure of the executive. That's because it's wartime. And they give you guillards, which they gave a guillards up here too. Now it is unlawful for a citizen to travel to Europe and impossible to enter European countries without a passport. See note supra number 4 above. The denial of a passport accordingly causes a deprivation of liberty that a citizen otherwise would have. The right to travel, to go from place to place as the means of transportation, permit, is a natural right subject to the rights of others and to reasonable regulation of the law. A restraint imposed by the government of the United States upon this liberty therefore must conform with the provision of the Fifth Amendment that no person shall be deprived of liberty without due process of law. I think I'm going to be using that right there. Oops. It is not procedural due process that is involved in the case now presented. There is no complaint the Secretary has filed to disclose the reason for his denial of the passport. Furthermore, a hearing of sort was granted appellant. He was at least given an opportunity to state informally to an official of the department the matters on which he relied in rebuttal of the reason given by the department for refusing him a passport. And they give you Bauer again and Nathan. What is involved at the present stage is a question of substantive due process, right? Which is 14th Amendment, I think, right? Whether the refusal of the reason given as alleged in the complaint and undisputed thus far by the Secretary was arbitrary. If so, it is not a valid foundation for the denial for the government may not arbitrarily restrain the liberty of a citizen to travel to Europe. Discretionary power does not carry with it the right to its arbitrary exercise. Otherwise, the exercise of the power itself would encounter grave constitutional doubts. And this right here is a great principle. This principle I learned through trust law, right? Because even if you tell yourself that you give the trustees discretionary powers to do something with the property, right? Well, that discretionary power is and always will be limited to the other provisions of your document, of your indenture. That's like a given. So to see it in this realm, right? That's how it's supposed to be. Like, wartime doesn't completely deny you of all rights. It just restrains some of them. And it's only restrained under specific instances under due process of law. Outside of that, I'm not of the camp where people believe that they can't tell you shit type thing. And that's not me. To me, I understand that we live in a civil society and we must respect our neighbors in some way, you know what I'm saying? And we have laws that apply to all of us for that specific purpose. But it is what it is to some people, and, a lot of people get in trouble for that. So what is arbitrary, however, in the sense of constituting a denial of due process depends on the circumstances. Right? So I'm going to read this because that's exactly my situation. Let me copy that. Put that right there. 1909. So just to get this right, 2/12/78. 2/12/78. Okay. They give another query. I'm probably going to read that one too, though, so I might as well pull it out now. You ever wonder why they give you multiple citations, right? This is the United States reporter, right? This is a Supreme Court reporter. And then this one right here is the lawyer's edition. What do you think the difference is between them? Annotations. More specific. Information, details. the rationalization of the judges and stuff like that. Like, what specific principles are they using? Like, I swear, that's where you'll find the good stuff. Restraint upon travel abroad might be reasonable during an emergency, though in normal times it would be arbitrary. World conditions and those in particular areas as to which the executive has special information and on the basis of which he is especially qualified to make decisions bear upon the question. For reasons thus suggested, the issuance of passports throughout our history has been left to the judgment of the Secretary of State under presidential regulation and is subject only to constitutional safeguards. And even these must be defined with cautious regard for the responsibility of the executive in the conduct of foreign affairs. Next case is Robeson versus Dulles, 1956. Supreme Court denied it. Pettyman, circuit judge. Appellate, so he's appealing it. Appellate Robeson applied for a passport. It was refused, tentatively refused, the government says. He brought a civil action in the district court, praying judgment that he is entitled to a passport and that certain regulations of the Secretary of State and rules of the Board of Passport Appeals are invalid because in violation of statute, the Constitution, and the Declaration of Human Rights, which the Declaration of Human Rights really means absolutely nothing. I think, like, that's not outside of something making it applicable, right? No. The complaint also prayed for a decree enjoining the secretary from continuing to deny a passport and directing him to issue one. The district court granted summary judgment for the secretary and dismissed the complaint. When Robeson applied for a passport on July 29, 1953, he was informed by letter that issue of the passport would appear precluded under the regulations by reason of alleged communist affiliations and activities. He was advised he had a right to seek further review by the passport office by conforming with certain regulations. Robeson made no answer to the letter, which you already know that's dead right there. When he applied for the passport a year later, he was given the same information and again failed to reply. When he later amended his application, he was advised by wire that in the absence of reply to its previous letter, the department was forced to assume he considered himself ineligible under the regulations. Robeson replied that the regulations were invalid and he intended to seek judicial relief. So what is he said? When he later amended his application, he was advised by wire that in the absence of reply to its previous letter, the department was forced to assume he considered himself ineligible under the regulations. Robeson replied that the regulations were invalid and he intended to seek judicial relief. The department again wrote Robeson advising it would be necessary for him to proceed in accordance with the regulations if he wished further consideration by the department. He replied declining to execute an affidavit concerning present or past membership in the Communist Party, which affidavit he understood to be one of the prerequisites under the regulations to informal hearing in a passport office. He asked for final decision. The department wrote him that failure to execute an affidavit did not preclude the informal hearing afforded by the regulations, but that at such a hearing he would be expected to answer questions concerning past and present membership in the Communist Party and later to confirm his oral statements in an affidavit. Robeson made no reply to this letter, but instead filed his civil action. You could tell right there he is already messing up on his administrative process, right? The communication back and forth. Even if he replied, if he was replied in such a way as why he's not. You know what I'm saying? Robinson failed to exhaust his administrative remedies. We think he was required to do so. He did not ask for a hearing, but instead asserted the invalidity of the regulation providing for one. Man, like what he said right here, I guarantee you could find 10, 15, 20 people in any group that you're participating right now or more that are doing the exact same thing because they think that the law don't apply to them in some way. That way of thinking. I kick those people out. I don't care about them. That type of, you have to give more for me to consider what you're saying. Certiorari denied. Well, they give you National Lawyers Guild versus Brownell. Certiorari denied. So they're using that case on that he didn't exhaust his administrative remedies. We cannot assume the invalidity of a hearing which has not been held or the illegality of questions which have not been asked. The judgment of the district court will be affirmed. I mean, that's like straightforward. And that also too, that tells you that, I understand this is 1950s, right? But damn, where's your homework at, bro? Where's your research on other court cases, of similar situations? There's no doubt, especially if he's a part of this movement, right? You would think that there's other people in similar situations that are either going or have gone through court already. Let me see how many more court cases they had. That's two pages, 2, 3. That's 3 and 4. Okay, so I'm gonna do these court cases in multiple videos. I don't want them to drag along. I want you guys to be able to go through my videos because I know I can. I am known for putting people to sleep, so I was told I have a monotone voice. But next video I'm gonna start with this, and it's a continuation on these court cases. So. Hopefully you guys enjoyed this video down. Hopefully you guys are caught up. And of course, like and subscribe and join my Telegram, join my TikTok, join me here or whatever on YouTube. And ask questions, man. Always ask questions. Otherwise, you're restricting yourself. All right. Have a good one, guys.